There's one thing I learned from the president. Cyril Ramaphosa said at one point when all these issues of allegations happen and all of that, he said, it's okay and it's easy for someone to allege that you've done so. But the bigger task is for them to follow through and prove what they're talking about. And in any case, you can never stop somebody from alleging. Perception exists. And you make rulings based on a party's perception. So conduct even during the break, right? I even said, even if one party offers you water, do not take it.
Jeez.
Don't get involved in anything that creates perception.
Bafana mates.
Why would, and when eventually I lose, we receive letters and specifically saying, please get involved. In the provincial legislature said CCMA has come and mediate because...
Wait a minute, this taxi scenario.
Yeah. And
how is that a labor issue?
It shouldn't be.
Crazy. I remembered another loophole.
Yes.
In the law.
Yes.
Auditor General not being empowered to make bigger decisions than just finding the facts.
Yes.
They walk into your office as CCMA. They audit, they found manyofonyof.
Yes.
All they can do is just write.
Yes.
Or we found manyofonyof.
Yes.
And that's it.
If you see people who are at loggerheads, at war with each other, and I settle that, they go peacefully. Why wouldn't I celebrate that? I take pride in representing an institution that does that.
Yeah.
You can't get any other satisfaction beyond that.
King David Studio podcast.
Here's something that stands out about law as a whole. Because CCMA process is a legal process.
It is.
Yes. Is the words and the language that one general everyday guy is confronted with these words as even a person who's educated, not necessarily someone who's a domestic worker or a petrol attendant, just a guy with 2 degrees in biology and having to deal with a CCMA case and there's words what?
Condonation.
You see? Yeah. Even I can't say it. And I have a master's degree.
Yeah.
Some of the biggest challenge for me with the law in general, and I guess that's what happens in professions, is that it has a language. Ultimately, you get the language, life gets easier. Can I present a case at the CCMA in any language?
Yes, you can. Let me explain what I mean by that.
Any official South African language.
Yes. Yeah. Generally, all our processes are done in English. Our awards are done in English. And in my time, I then said, even in a conference full of commissioners, I said, my research reflects that when somebody presents a dispute in their own language, they present it better without translation. And it also comes with the foundations of transformation as well, right? So if I want to present my case in Afrikaans, I should be able to do so. I must be able to do so, right? And also that includes courts as well, because English and Afrikaans are foreign to me. And before I can understand the content, I must first understand the language, because I can't express it without that.
Yeah.
If we are serious about the constitutional right of 11 languages, it cannot be applied in certain limited instances. One thing that I have experienced, which is a problem, is when we use expense as a reason not to use it. It's expensive to do so.
And CCMA would use that reason.
People would, when I came at the CCMA, when it comes to making an award, they say, but the problem with that drafting an award, labor court for review, then how do you deal with that? It becomes an impediment.
Yeah.
And to translate it, it costs money. But translation things get lost.
True.
Why can't we have an arbitrator, KasiZulu, with Party Bakhuluma isiZulu, make an award in isiZulu, and then, to me, that's equity. Because you said it's constitutionally protected.
Yeah.
I was made to understand an award in Afrikaans, right? But the award is mine. So when you employ and train your commissioners, get those that are in those different languages, so that when we allocate cases, we've got a Tsonga arbitrator.
True.
You go there.
Yeah.
You go and appear there. Even if I'm a representative, I'm not speaking Tsonga. Let's translate for you. That's what has been happening when it comes to translating other non-English languages into English, because we've got interpreters. So when we interpret, it shouldn't be one-dimensional. That is why when I went to our conference and I said, the time has come, and I'm glad that, the Supreme Court of Appeal and all of that, I think Justice Meyer is one of them, who issued a judgment against Xhosa.
Yeah.
And I'm talking about well-spoken is Xhosa, right? So if we can do that there, why can't you do it here?
True.
Because there are persons who are sitting in our cases, because the majority of the people we service are people who are vulnerable in terms of money and all of that, and sophistication. So when he comes in and says, right, that's a dismissal. And now for him to tell his story, undiluted, let them tell the story, and the commissioner must understand everything that I'm saying.
That's true.
Why is it that if all parties, why do we convert into English? What are we doing? Is it easier? No, it's not. But to me, it's a two-stage process. I must understand the English first before I can talk about the content of my issues and law.
True. So you're dealing with
levels.
You're dealing with language as a huge impediment.
Purely on its own, right?
Yeah.
I hear sometimes when legislation, they say that the president signed an English version, not the Afrikaans version. I said, I understand that. But let's get to basics and practice. What does that mean?
True.
The debate and legal issues that arise there, right? When it gets to the hearing room, it reverts back default to English.
Yeah.
I attended a conference of international agencies like the CCMA. We've got UK there. You've got, all of these countries, United States and all of that. They said to me, we are English speaking. All our processes at home, it's English. So we understand the dispute better and we're able to resolve better. You don't, because language is still an impediment. Some people, when things are translated, they still not follow. Some, it's fear. And all of that. Law must not, in our mind, automatically translate to English.
Yeah.
If I'm fluent in English, does not necessarily mean I'm intellectual. Right? I may be good in language, but I may be very intellectual, but can't speak English. When I attend the ILO, there was a session before COVID, where, because mostly people, they speak French, right? And when you get to the ILO, there's translators for every language there. But there's not
those little boxes.
Yeah.
Yes.
But there's no one Yesizulu. There's no one is Xhosa there. Why is that?
What is it? Is it the assumption that Xhosa-speaking people can speak English?
That we are English speaking.
Yeah.
And even when people talk to me, they said, are you English speaking? I said, no, Nkhuluma. And I said, excuse me, Nkhuluma. They don't even understand what I'm saying. So when I go and present myself, let me bring in translator from Mzansi to translate for you
them.
In English.
Yes.
That to me is equity.
Ooh.
Right? In addition to that, the French, I remember, in an Africa group where we met and discussing, they needed a French translator. There was none. And the meeting didn't proceed until there was a French translator.
Yes.
So why can't I rock the boat?
Do you realize that you are even talking of an international platform?
Locally.
Here we're talking about someone who bamqoshile emsebenzini and they come and say, I need help.
He sits and said, again.
Yes.
Let me tell you what happened.
Do you have those resources currently?
Yes, we have interpreters.
Yeah.
We employ interpreters that interpret that, but awards end up in English. And after my conference with commissioners, I said, I'm saying draft your award in isiZulu if you can. And one was drafted. Now we had to adapt and change policy. And what is more interesting to me, if that award gets reviewed, and when you go and get a transcript, in isiZulu. So when you go to court, so someone must translate for the judge about what you're saying in a isiZulu written award.
And translate for the employee, for employer as well.
To understand what you're saying.
Yes.
But you know what I find it even more interesting, David? You find that everyone who khuluma isiZulu in the hearing room, bonke basizwe isiZulu, they are in deep, serious twang English. Right?
Wow.
And
it's the nature of our country, though.
But why are we doing this?
Yeah.
No, it's expensive. No, the review. No. If we're going to give those excuses, until when? You've got the Pan-African Language Board that exists, that in terms of constitution, they must promote the usage of all languages.
Yeah.
At what point do we punish for lack of usage of our own language? And don't look at language as a standalone. Language goes with culture.
True.
And culture is constitutionally protected.
Yeah.
If I prefer Afrikaans and I want my word to be in Afrikaans and all of that, let's allow you to. But equally, the same principle must apply.
Yeah.
There has to be a time where we have to take the pain of having to allow that to happen. Otherwise, it becomes just a fallacy to have languages. Now we have sign language. That is now admitted
as an official language.
Official language, right? So here's a trick here. Even in this session, if I'm deaf, right, and I want to listen to what's
being said here,
what then happens?
Well, we strap at the bottom.
Then everyone who is not able to hear won't hear your show.
Yeah.
Because it has to be in Braille. And Braille is expensive, they say. So if we legislate that sign language is an official language, I accept that. But how do you translate into practice? So it means, therefore, if you're dismissed and you use sign language to speak, in the hearing can't proceed until somebody understands what the sign language says. Because if I give my testimony using sign language, then it's stagil. Because no one understands sign language. And if you don't make provision for that, that's discrimination. If you say, I can't do it, not because I'm not willing, but because I can't afford it, that's indirect discrimination. So that sign language, which we proudly and happy about, right? And these other languages as well, we take pride in them, but in reality, we're doing exactly the opposite. Dispute resolution must be driven in a preferred language without using expense, convenience as a reason not to do it. If I speak my language, do your best to understand my language so that we can understand each other.
Do you find that the system acknowledges this challenge, or excuse of money continues to be the reason why it's not done?
Money.
It's always the reason.
Yeah. And you know what pains me? And when I walk into a conference of the CCMA, I know I have, even though there are very few, maybe a handful of commissioners that can't hear, others that can't see. If I put up slides on the screen and I do this, right? Because I drafted the slides and it's and my passion of it, I keep talking without looking and reading the slides. So someone who's not able to hear, then there's a problem. Because then you need to relate.
They can't follow.
So they can't follow me because they're not hearing me. Even if I decide I'm not using slides, I want everybody to engage with me. He's sitting there, right? And then I speak, but he can't hear me.
Yeah.
He's excluded. Effective, but he's a commissioner. Even a staff member sitting who's got interest, they're excluded. Said, okay, I can't talk much, I'll summarize, but the rest is on the slides. But the one who's blind can't read them.
No.
So that person is excluded. This falls into those cracks. If we talk equity, it must not just be in language, it must be in practice. So that you become sensitive that when I sit in a hearing, that this person wants to tell his story, then he must tell it in his language of preference.
Yeah.
Then I must make means to accommodate that. We did try, and we did put other forms in other languages, right? It's there. And you can use, but even if you use that there, it must not end at referral. It must continue all the way to arbitration. That referring as Zulu, hearing must be as Zulu, the award must be as Zulu. Where's the breakdown?
Yeah, do you realize that it also goes back to where we started about education?
Yes.
Where all these words must be understood even at a much lower level.
Yes.
And if we are going to understand them as employers and employees, it must be understood by everyone.
Yes.
all around
Yes.
in the language that is preferred.
Yes. My worry is also that, David, linked with exactly the point you're raising. People with disabilities are also protected by the Employment Equity Act.
That's true.
But how far do we do it to protect them then?
Sure.
Protection is not just recognition. That people with disabilities are also supposed to be the beneficiaries of Employment Equity Act. But in practice, we must accommodate. While we're talking reports of equity, how many big corporations, how many public entities are led by people with disabilities? We must then practically ask, 29 years after democracy, and we're talking equity of people with disabilities, all forms of disabilities. Why are we not having that? And when we look at equity, therefore, we're not limited to race, we're not limited to gender. We must look at the different categories of disabilities included in that as part of the equity of the designated groups. And then say that we make noise about race and other, we have not done well, as we discussed. Yes, the Employment Equity Commission report is a fact, it's there. We accept that, it's true. We've got problems there and we must get it resolved to achieve equity. But what about equity on gender? What about equity on disability?
True.
How many times do you read in the news, you hear noise about people with disabilities not occupying key positions? We are not discussing that. We think discrimination automatically it's about race and gender.
Yes.
It's not correct. It's the same thing when you're talking about gender-based violence. It's not sex-based violence. It's gender-based.
All genders.
All genders who are subjected to abuse, who are GBV'd, they are victims of GBV violence. Therefore, when we're talking about, you see, when I was an attorney practicing, there was a time when I had a client who literally was raped by a woman, right? And he explained to me, but it took time for him to come to me. And he said, but it's a criminal case. You go to the police, you report this, and then the person must be prosecuted. And at that time, rape was still defined as a man doing it to a woman.
Okay.
It did not have as evolved now of persons, which is more accommodative, right? But that was not the only problem, because that first problem is that when you get there, the law kicks you out. How can a woman rape a man?
You?
And by definition, we don't have that, right? So that's exclusion.
It's not a crime.
It's not a crime. Come fast forward, it's now a crime, right? Just to see a very sophisticated form of gender-based violence. So the same guy goes to the same police station. I have been raped. They look at him and say, but you're a guy. Yes, I am so, but I have been raped. But for him to walk into a police station to do so, it's an issue of dignity. I'm a man, I cannot be raped. Therefore, even in some cases, even at that time in my practice, he came to me because he was mocked by the police. You are a weak man. You ought to have enjoyed it. What's your problem?
Yes.
How can that be rape? How can you be forced? They're looking from a penetration point of view. But that's not the issue here.
No.
That's not how you define rape. It is about consent and lack of consent. That's the issue. So when we debate issues of gender equity, we have to understand it, that I can be sitting in my house, Maria Kalindu, I don't get food, my salary gets taken, and we are subjected to that, but I must not be afraid to say, I am being victimized. It doesn't matter whether I'm a man or not. It's gender-based. It's not sex-based.
Wow.
So the terminology in law, as we use it, for our benefit, like the French, like everybody else in other countries, I was supposed to go to Colombia to present at Colombia, and we have to do an online. They said, you see, if you came physically, we had made provision for you to be translated because the majority, if not 90% plus, people speak Spanish. Now that you're doing it online, they won't hear you.
It's worse.
I'm not even talking Zulu.
You must speak English.
Compromise. In English. I said, well, if it is English, well, we could have tried to translate for you. If I said, that won't even start. Right? But if people from outside coming Mzansi to present here, why can't I use the same requirement to respect my language and culture because you're in my land? Right? Well, in you know, it happened, and even people thought it is negative. I was in KZN, and I was going to speak to our users there, right? They punished me. I came in there, started speaking and delivering in English. They just kept quiet. And after speaking for 15 minutes, what no. When you're ready to talk, then you let us know.
I like that.
Said, what does that mean?
You will get that in case it is. I like that.
Already, right? And on quick reflection, said, oh, konjing, KZN.
Yeah.
Everyone in here about Zulu. Then I stood up and said, but now we are kuluma much. Then I spoke. Yeah, where order. Now, I then started speaking isiZulu and explaining the same thing isiZulu. And it was the first time I got tested unexpected.
Yeah.
Now, things that I know in English, I had to translate in isiZulu. And fortunately, eskolweni from isiZulu as well.
Yeah.
My grandmother Mxhosa, so I'm a cocktail. Right?
Yeah.
So after speaking, time for questions. One raises a hand. He asked a question in English.
They're just intimidating.
Yeah, and I said, but guys, you took me through 10 minutes, but you're asking questions.
You had to end your keep.
Yeah,
you can't just.
Yeah, when you're in Rome, do what Romans do.
That's
right?
true.
But that was not wrong. That was respect for language and culture.
That's true.
When you come to my house, you must play by my rules.
Yeah.
And the best form of respect you'll get if you respect my language and respect my culture. So I've learned to be dynamic, to be versatile, right?
Have you applied that to your office as well?
The same principle applies. My staff will tell you, when I get a call in the morning and somebody, your phone, hey, director, we've got a problem. I said, as in for Dagasha no 9, so in English. And I'll sit in an EXCO meeting and say, but everybody like understand this is as or as a status clause. That went so to her and all, because to be a dynamic South African, you have to know more than one language.
That's true.
At least our African language to know that. And we need to do that and encourage it, not by ngani, but we do it because it's necessary to do so, right? And so that if we translate like that, it translates to pride. It enhances one's dignity. And I feel good. When I watch Ilembe, right? And I listen to isiZulu Skrunyolap. When I listen to programs as Xhosa, we have such beautiful language.
That's true.
Beautiful. How am I to speed? Ne? Motu one speed is a thing. You like Marwai. We're not enjoying that. And for me, is language and culture is important for dispute resolution. We must enhance it. The caseload we see, I can tell you, I can bet it will change.
Yeah.
Because we understand the dispute better. And the one who's complaining can explain it better in the language that his mother tongue or her mother tongue.
And, outcomes of, and you're talking about the outcomes of the cases that you find. Do you have any statistics in terms of the cases that you find in relation to outcomes and what type of cases do we find? Because most of them, I imagine it's unfair dismissal. That's likely to be the highest.
It is the highest.
But as CCMA, your role is not only to deal with Bankoshile Msebenzi.
No, it's not.
What other issues do you deal with?
Let's settle a correct fact that you made.
Yeah.
Unfair dismissal is the highest.
Yes.
That's settled.
Yeah.
Right? And the majority of those is misconduct cases.
Okay.
That's the biggest part. Right? And then the other disputes we deal with, it's unfair labor practices. Right? Where there's a suspension, where there's, salary deductions without authorization, for example, and issues of promotions, issues of demotions. That's all part of the family of unfair labor practices, right? Then followed with that, you have the the employment equity, the discrimination cases. And in the discrimination, you have harassment. In the harassment, we have sexual harassment.
Okay.
That's the type of
Amongst
cases,
others.
amongst others that you deal with in the equity space. Then you have the minimum wage one.
Okay.
Purely financial there. I'm supposed to be paid 21 rand. I'm being paid 20 rand.
Yeah.
Therefore, the employer is. When it comes to that one, the biggest challenge I have with that is that somebody can decide to review an award we make on fighting about the 20 rand.
Yes.
But we take it to the labor court. At the time when, national minimum wage was enacted, one of the things I raised was exactly that. Why should a review be available
for this?
To a minimum wage issue? Because the issue is not so much about big monies here. It's not unfair dismissal issue. It's about the 20 rand.
And also it's not a technical thing. It's a clear cut and dry
It's a factual issue.
Yes.
You're supposed to pay me 20 rand. You're paying me 19 rand.
Yes.
And
why are you reviewing?
And if a commissioner says, well, you were wrong, then you must pay 20 rand, and I'm not happy, go to the labor court, what are we doing? How much are you going to spend fighting that, actually? How much are you going to spend doing that? Because it's available, it does not necessarily mean we must use it. There's a report, David, I don't know if you've seen, which I take interest in the context of your question.
Yeah.
Because of the financial strain in the economy, because our unemployment is sitting at 32.9 or so at the moment. Domestic work is bleeding jobs because of the economic pressure. Domestic houses are unable to sustain the costs of keeping domestic workers. That sector is suffering. And some of those has to do with unfair dismissal. Some of those has to do with issues of unfair dismissal, but in the form of retrenchments. People sometimes think that cases about domestic workers are simple. No, they're not. In some cases, yes, they are. You come in there, good Sophie, yes, you broke my feather duster, and I don't have money, and you are hiding it behind the curtains, and then she gets dismissed, and it comes to the CCMA.
Sure.
It's a case.
Yes, you have to deal
with it, right? There's a case I dealt with where a domestic worker was dismissed because he packed the fridge badly. If fish butter, you must pack it at the bottom, not at the top. And they got dismissed because of that. And the case sits there, right? The complex part is on inspection and enforcement. And 2, because of access to a workplace called work. Remember.
What do you mean inspection in this context?
The Department of Employment and Labor must access workplaces to inspect whether there's compliance.
Okay.
And if there's no compliance, they issue compliance orders.
Got you.
In some farms and also in some domestic houses, they can't access. It's locked. In some cases, it's open, but there's very wild dogs in the yard.
Yes.
And in some cases, they're simply not allowed to enter. Pure and simple. So when a domestic has to refer a case also, they need to leave the house and go to a coffee shop and go and refer a case. But the complex part of it is, if it's a retrenchment case, for example, part of the requirement is disclosure of documents, which in some cases include financial statements.
By the employer.
Because we're retrenching. Right?
And it is.
And if your defense is affordability,
sure.
So as one, I'm a bank accounts. But then you are hit by something else there.
Well,
privacy and confidentiality.
Oh boy.
No, this is my house. But you forget, for the domestic worker, that's her workplace. Retrenchment is an employer dismissing an employee. So then you have to fight that battle before you get to the real issue that we are talking about. On the actual issue of retrenchment, we are fighting about document disclosure. And in some cases, people have multiple accounts.
They only show you one.
Yeah, but okay, each check account as FNB is the one that is paying salary. But when the dispute arises, I capital. I know money. So you see, I don't have money. So that's why I retrenched. You can't keep searching and checking other accounts to check if I have money or I don't have money.
How rife is that space? Or domestic worker dismissals?
They are. Yeah. They are really. And that's why we've got unions that deal with domestic workers. That's why most of our cases, we do what we call pre-conciliations, because those ones we can do on the phone instead of them coming over.
Yes, of course.
Because of those complications. So we are able to deal with those on the phone. And we've got a very good success rates there.
So it's not unusual for me to lodge a case and get a call from CCMA?
No.
Saying, look, we got this, let's talk about it.
Yeah.
Yes.
But you must verify.
Okay.
Because it could be a friend calling you
Course.
and doing all of that and misleading you. In fact, we should also, from the CCMA side, put controls to make sure there's a way of presenting ourselves to you so that we can see and know that it's us.
Yeah.
There must be an authentication process to make sure that it's real. So we do settle many of those cases and people get paid and the matter is resolved. We're calling it the pre-conciliation dispute resolution process. And we are very successful in it.
Yeah.
So in a domestic sector, because of that, because of the nature of the issue, because of the relationship, because of access issues and all of that, then the case becomes more complex, even though it looks simple.
It should be simple. Do you know why I think so?
Yes.
You're dealing with two people, essentially.
Yes.
Maybe the other side, it's a family.
Yes.
But you're dealing with, it's a simple setup.
Yes.
Where I didn't pack the fridge correctly.
Yes.
How did that case end up, by the way?
We settled on it and she went back to work. And
she went back.
It was
another thing you're dealing with, and you say it so simply that she went back to work. We really don't want this person anymore. You're dealing with that as well.
Yeah,
where the real issues are other than the fridge.
Yeah.
Relationship. But the relationship doesn't work.
By the way, there's also cases of abuse there.
Yes.
You know, there's issues of rape as well. In some cases where a domestic worker comes and no, I've been raped by the employer and all of those kind of things. And it because it's the setup. But the rape one is very rare. We get that, right?
Yeah.
Maybe there are other unreported cases. In fact, I intend to meet with the unions dealing with domestic workers to talk about those type of cases.
Yeah.
There's a case I want to tell you about, which is interesting, that I did, where the domestic worker was employed by this family for almost 20 years. In fact, that case I was talking about earlier of the domestic worker died in the pool that ended up at the Concord, but it was the daughter who fought the case.
Yes.
Because the mother passed away.
Yeah.
She died in the pool, but she worked there for 26 years, I think, in that workplace. Wow. Can you just imagine?
Jeez.
Children were born there,
raised the kids.
Them so it's a very special type of workplace. So in this case, this lady felt so abused such that she decided to leave. And then came to the CCMA and claimed unfair dismissal. So I was exposed to conciliating that.
Yeah.
So they came in there. When they came in there, and there's lawyers there, two of them, I said, but against the domestic worker. You know? They said, hey, Commissioner, please don't be alarmed that we are here as lawyers. There's a context to this. You see.
Who are they representing? The family.
The family.
Yeah.
Right? They said, look, she's been working with us for 15 years. And she has seen our kids, even the owners of the house. And the husband died. And the wife is the one left. And she also has disabilities and she's ill. And Commissioner, what can we talk to in private? There's things we need to say that we can't disclose. So we go to a side caucus. I explained to her. So in the side caucus, they say to me, look, this domestic, she is in the will.
Ooh.
She stands to inherit this house, this mansion you see. The child is taken to private school by the family. The only condition, she needs to remain in employment until this one passes away.
The wife.
Left, because there's a joint will.
Okay.
But she doesn't know, the domestic.
The domestic doesn't know.
Yeah, doesn't know that, right? So in this case as well, we did not dismiss her. We're not going to argue. We are experts on wills and test and all of that. But not on employment law. We're not here to come and argue. We just want to present this part so that you know.
Why was the case in front of you?
Because she left. Because she was fed up.
Okay.
Right?
Okay. So and they didn't want her to leave.
No.
Yes.
And then I asked her, so Kanti yini? You know? No. This woman abuses me. She does this. She gave me a long list of things that makes her unhappy. Right? So I said, okay. So then did they dismiss you? No, I decided to leave. But the education issue. She doesn't know that we can't just leave and claim unfair dismissal unless you can show constructive dismissal.
True.
Which is a higher standard and very difficult to prove.
Yeah.
Right?
In this context, she resigned.
She just resigned effectively,
yes.
right? But then claims unfair dismissals. So I said to her, okay, now that you are saying so, are you willing to go back? She says, no.
But let's pause 1 second, go back. If she's abused, because it could be constructive dismissal.
It could be.
Yes.
Yes.
Where we don't want her, we're frustrated.
Yes.
So that also is a possibility in her case.
There is a possibility, but to get to that, you're going to need evidence to do that.
Of course.
And you're going to, and that complicates it, right? So because normally when you're trying to conciliate, you do ask those questions.
Yeah.
And they say, what is it that you have that you can show that you are being abused, like you say? and I can't see anything I can put my hands on, right? And I realized, hey, my prospects are weak here, right? But you don't make that pronouncement because at conciliation, you don't do that. You show light and you indicate, but are you aware that you need to prove this? Are you aware that to this, for constructive, you have to listen, I need to bring those facts to you so that you can evaluate and make an independent decision on whether you want to settle or not.
Yeah.
So I tried to do that. But the problem I had at that stage is that now I'm aware, because that what she stands to benefit.
There's a will in place.
There's a will in place.
But also,
I'm locked by confidentiality. I cannot
disclose to her
without consent.
However, I think there's also an error in judgment by the family for not disclosing what she's rightfully supposed to know.
Yes. But in wills, there's no duty to. There's no duty to disclose.
Yes.
Right? And also, it's a safety issue. Because if I can only bet Hatsamaya,
I'm coward. No. Right. Okay, I get you. I get
right?
you.
So there's that safety issue as well, right? So they don't announce that, right? They said all she needed is to hold on until the moment arrives.
Yeah.
And when her
could be in 20 years, could be now.
She's well paid, way above many domestic workers, by the way. They showed me the salary, and I confirmed, is this what you earn? About 9.5.
Yes.
Right? Is this what you earn for domestic work? I said, yeah. Do you sleep as well? Yeah. Do they pay for your kids? Yeah. So do you have a medical aid? Yes, I do.
But I'm fed up.
But I'm fed up. And I'm sitting there.
She has a right to be fed up.
She does. Yes. I can't put myself in her shoes because I don't have facts. But I'm at pains because I know what she doesn't know. And by the way, what she stood to benefit was not just about the house. There were monies as well.
Jeez.
That she stood to benefit. Huge monies. Because of how she's been to the whole family, the children and those that were sick. They were truly, truly and deeply, grateful of that. And the lawyers, they really, really tried. They said, look, we can't disclose this for the sake of, now you have no right to disclose. We're telling you because you said the discussion is privileged.
Yes.
And I had to protect the privilege. I tried. Conciliations don't take long, but that one, it took the half day. Right? Take a break, come back.
Because you try.
Can you just understand? This is the issue here. And they can adjust and they can do all of those. I've really tried from all angles to try to balance that. I did not win.
Sure.
At 1:00 and having tried everything else. And these lawyers were patient. Said, no, we'll sit here. She's valuable to our family.
Wow.
And that only, this is the only person she understands. And wants no one else. Just her.
Wow,
I'm done. If you leave, you're going to lose medical. Your child will be out of school and this and this. And this. I don't care.
Yeah, she
was thoroughly and effectively, fed up. And I said, okay, I couldn't settle it. And that was it. I had a very difficult day.
She lost out.
A lot. She stood a lot to lose. Wow. And she did.
If you didn't know Louis.
No. I said to them, if there was a way, if you find a way to come back, please do. Let's try again if you could.
And that was the end of it.
That was the end of it. And I said there as they walk away, and I said, if only you knew that you're rich, only if, I would
stomach the nonsense.
I would hold on, and be good as you've been. That made you to be what you are today.
Deserving of this.
Deserving of that, because they clearly said, they did tell me all the things that she did for the family.
Yeah.
But just because of the one left and the fights that they have, she couldn't take it. And that's how she lost out.
So the role ultimately of CCMA, so there's a clear understanding, is to bring about a peaceful resolution to these disputes.
Yes.
It by no means it should feel like a legal environment.
No. In fact, the LRA specifically says so.
Yeah.
It says that as we deal with dispute, it must be with minimum legal formalities.
That's exactly that.
And it must be inexpensive and it must be quick. That's a clear expression.
That's your mandate.
That's our mandate. If you look at chapter 1, in fact, section 1 or 2 of the LRA, we look at the objects and purposes of the Labor Relations Act. It talks about labor peace.
Yeah.
You know, if you see a strike, it's a constitutionally protected right, and there's always good reasons why people strike. But when we intervene in that,
which is your another one of your mandates, yes,
is to mediate and find a peaceful resolution.
Yeah.
And we've done exceptionally, more than 70% of our cases are settled.
But you don't deal with every single one because some of them are not within your jurisdiction.
Let me explain that.
Yeah.
There's a section in the RRA called Section 150. We can intervene in any dispute.
Okay.
Provided it is of public interest, right? And if it is of public interest, we can intervene, even if the dispute is not referred to us, right?
Okay. You can say, Siangena.
Let me give you one of the latest examples. We got letters to go and intervene in the dispute as a Cape Town.
Now.
Yeah, the taxis one. Yeah.
Yes.
We received letters and specifically saying, please get involved. In the provincial legislature said CCMA has come and mediate because...
Wait a minute, this taxi scenario.
Yeah. And
how is that a labor issue?
It shouldn't be. Let me put it this way to you. Yes, from the LRA, it has to have the character of labor. But firstly, the users of the CCMA can't access work because of the strike.
Got you.
They can't come to CCMA referred disputes because they can't commute.
Got you.
Employment is at risk because they can't get to work.
And this is a commuter.
It is a commuter.
Yeah.
Commuting to work.
They can't work.
To earn income.
Yeah.
So they can take care of their families. Others must travel to cases they can't.
And it automatically brings it to your jurisdiction.
Then it comes within our fold.
Wow.
And then I said, well, it's not referred. And there are those elements of it. And we're talking about taxi drivers. Who said taxi drivers are not workers?
Yes, they're workers.
They're
actually,
workers.
the only thought I had was that it's the taxi drivers that are in the picture. Now, when you said commuters are equally part of the story.
Yeah. So,
wow.
Interestingly is when you're talking about a taxi driver, constitutionally, that's a worker. He's aggrieved because there is an impounding of a tool of trade.
That's it.
Which is a taxi.
Yeah.
That's a tool of trade.
Yeah.
Right? So when it's impounded, it doesn't matter who's impounding it, who's involved in it. But the tool of trade is impounded.
Yeah.
Right? So you don't determine a dispute by looking at it from a distance. You have to be here for me to know what it's about. And there are those elements that I've just explained.
Wow.
The same thing when you're talking about Uber drivers. Exactly, we call it e-hailing. Platform workers. They are workers, right?
So do you then get involved? Let me ask about this particular one.
Yes.
Did you get involved?
We did accept.
Yes.
That we're going to get involved and mediate. Here's what is interesting, David, and this must be clearly understood. When you're a mediator, you can mediate anything. There's divorce mediation. You can mediate it.
That's true.
There's commercial dispute. You can mediate it. That's why...
And CCMA?
We can.
Wow.
There's nothing that we can't mediate.
Yes.
But
does the Constitution empowers you to do that?
No, it doesn't.
Yeah.
You see, technically speaking, our jurisdiction is limited to employment.
Okay.
Right? So if companies are fighting, we don't have jurisdiction, technically speaking.
Yeah.
But if we get approached...
And they say, we need your skill.
We need your skill. Because what you need is not employment law. You need the skill.
Yes.
Please assist.
Yeah.
You know, you are assisting. It's a dispute.
You're a hostage negotiator. Come help us here. There's a guy here. So it's the same application.
You can... That's why I said to commissioners, when you get trained as a mediator and arbitrator, first you must be a dispute resolver before you become a specialist dispute resolver.
Before you become a specialist labor dispute
resolver. You become divorce mediator and all of those construction resolver, because there's different forms of that dispute. You know, interesting enough, I remember when we were trying to deal with the land dispute, because there was an attempt that for us to be involved in land disputes, by the way. The Department of Justice, the minister says, we are going to include you in the Act so that you mediate and arbitrate land disputes. Jeez. We met different mentors from the agriculture and all of that. We pushed the draft bill. We got us in there. Eventually, we didn't end up there, right? But here's the important thing.
Yeah.
When that was done by the Minister of Justice at the time, and also including the Minister of Labor. They wanted CCMA to mediate a land dispute. Is that a labor law dispute?
It's not in principle.
It's not. It was a bill that was made for us to mediate a land dispute, which has nothing to do with employment. There are aspects of the land tenure issues, the farm workers who work there, but that's not the reason why we're brought. It's not to resolve farm workers dispute, was to resolve land dispute in terms of Section 25 of the Constitution.
You can argue that it affects farm workers.
It does affect farm workers, but that was not even the consideration at the time. The issue was the speed at which we resolve land dispute is slow. And it's been dragging for more than 2 decades. It's causing frustration. And you know, in the political circles, the land issue is the big issue.
Yes.
Said, but the
if
people
not the
who can help
biggest.
us resolve this is the CCMA. And we wholeheartedly accept that because that's a constitutional obligation.
Sounds like adventures. Like, hey, just let's go to that one.
Yeah. But there was an interesting submission made there.
Yeah.
And I didn't verify this. They said when CCMA actually, when it was created, while it is correct if you look at the history, employment law, industrial relations and all of that, but one of the thoughts was that our mandate should not be limited to labor. If there is a dispute of service delivery, happening in the township, if you've got the taxi disputes like you have now, who must be called to resolve it?
As we speak, there isn't any other resolution.
No, there isn't.
Dispute resolution.
No, there is none. It's just us. It's just us that exist.
But you are only limited to what you're limited
because
to.
by law. But that's why, therefore, the land dispute, when it was introduced, they said, well, we'll do so. And in fact, if we do so, we'll expand and change the labor relations to accommodate that. It's just amending the act. So why can't we then say, because of these experiences, why don't you expand and fund it as well? Expand the jurisdiction that other disputes which are not necessarily labor, that we can intervene in the interest of justice.
Because there's no other tool in the system.
In fact, magistrate courts now have introduced what you call the annexed mediation, right? So before you litigate goes to full trial, you've got to show that you attempted to mediate it and it failed. That's how important mediation is. That's how powerful mediation is.
Yeah.
So if that's the case, then how are we different from that?
Jeez.
You can mediate those disputes. The important thing, you must have the necessary skills to mediate. You need to understand the flavor of the issue that you're at. If it's about divorce, so let's hear, what is the issue here?
Who did what here?
Yeah. You know, when I got trained, when I was first introduced to dispute resolution, it was before the CCMA. I was trained at the Arbitration Foundation of South Africa.
Okay.
I was trained on ADR.
What is ADR?
Alternative dispute resolution.
Okay.
Right? Instead of doing courts, let's use arbitrations, let's do mediations, all of that. I did that for a year. I qualified as such. And even if when I came to CCMA, I was trained now in the context of employment law, exactly the same thing.
Okay.
Even while I'm here as director, I attended training where I was trained on commercial mediation by the Legal Practice Council with the Law Society.
Yeah.
Right? I did that training as well. So if you call me to mediate, I'm a cocktail. I can mediate a domestic dispute. I can mediate an international dispute.
You can mediate umjolo.
I can, in fact, you've seen on social media, people say, can you refer and unfair dismissal? But I strongly feel this is unfair.
Yeah, that's
you know,
wow.
You know, the type of thing.
Yeah.
So your skill of mediating and facilitating arbitration, right, is fundamental, to mediate. In fact, I feel strongly that when it comes to that skill, it must be done from school level. You must develop mediators and facilitators and arbitrators from school level. Disputes at school can be successfully mediated.
That's true.
In fact, when there was a fees must fall, remember that?
Oh, yeah.
Big
Remember it
fees must
well.
fall.
Yes.
We got a call from the university chancellors and said, and vice chancellor said,
we need somebody.
Can you please intervene here? Because it's not employment law. There may be aspects of it, but we are called to go and mediate. Did we accept? I accepted that.
Let's go.
So you see what I mean? There are real examples.
Do you volunteer when you see that this needs us and no one is calling?
Yes.
Yeah.
We have a duty to do so.
I'll tell you one. and I don't know if it's already on your table. City of Tshwane.
Yes.
It's a hot potato.
It's before us.
Before you?
It is before us, yeah. Because the issue there, the effect of that, and then electricity issues, and you saw the number of people that have been dismissed already.
Lots. Today is 55.
Yeah, and it keeps rolling.
Yes.
Right? The dispute was referred to us, and I did deploy 3 commissioners to go and deal with it.
Who in this case brought it to you?
It was the union.
Okay.
It was the union that brought it. But remember, there was the issue there. It's about an existing collective agreement which deals with salary increments. And first year was implemented according to and second year not. There was an application for exemption that happened, and workers were unhappy. They decided to go on strike.
Yeah, and they decided to go even against the court ruling.
They went and tried to obtain interdict on that matter. And that one is a purely employment law issue.
Okay.
It's a labor law issue because there's a bargaining council that exists. And in cases where a dispute is really complex and of serious public interest, we would engage the bargaining council and said, let's assist you. Sometimes the council that approaches us said, can you appoint senior commissioners to deal with this dispute? Because we feel that, complexities and all of that. So we did deploy. So I did deploy commissioners to deal with that case.
Explain to us the difference between bargaining council and yourselves.
All right. In simple terms, a bargaining council gets accredited by the CCMA.
Okay.
For them to do dispute resolution functions.
Dotted lines? Do they remain?
Yes, there's accountability.
A function of...
Okay. We have clear policy requirements that we've set on issues relating to the arbitrators that are there, the issue of independence that are there. There's certain requirements for us to accredit. And even if a council comes for renewal, we do test that and see, have you met our policy in terms of how you operate? And are your panelists independent or not? And all of those questions. So there is a certain measure of dotted line, but they are on their own in a specific sector and industry with boards, with general secretaries, with all of that fully functional on their own.
Who funds them? The sector?
There's the sector.
Okay.
Yes, there's levies that are paid and all of that. And we also subsidize them, by the way, because they're doing the function that we ought to be doing. And then we then pay subsidies to those ones that we've accredited in order to assist them to do the functions that we do. But on the decisions they make and everything is they're running, the management, the governance, it's entirely, they've got their own constitution, which we don't interfere with unless there's a specific reason for us to do so, because we accredited them to do those functions. So we've got to act in the public interest. But it's very rare you find CCMA interfering with the bargaining council and its functions, because we recognize it as an entity that is standing on its own, despite the fact that they are accredited by us. The commissioners that work there are our commissioners. They are accredited by us.
By you?
Yes, then they become panelists there at the bargaining council.
How does a sector qualify, and I'll use that word loosely, to have a bargaining council?
Is exactly the policy that we've created. They bring an application to us.
Okay, so any sector.
But it starts, any sector
can say, we think we need a bargaining council.
As long as you meet, like now, the security sector established a bargaining council. It exists. It's there. It starts with the constitution of the council, because a council exists based on a constitution, right?
When do they see the need? One or two factors that may say to them, we need a bargaining council, instead of having to take things to the CCMA?
One big factor, there's two main factors. Number one, it's specialization. Because it's sector-based.
True.
So they know and they understand the sector very well.
Better than you probably could.
Better than us.
Yeah.
So they have an extreme advantage because of that, and which creates then specialization. Two, the volume of cases. If CCMA did not have assistance of bargaining council, can you imagine the volume of cases we'll be dealing with? In some cases, when bargaining councils collapse, those cases revert back to us. Because we have to deal with a primary dispute resolution institution created by the LRA and giving us power to accredit bargaining councils to assist us in dealing with dispute resolution.
Got you.
So it's because of that, sector-based specialization and also volume of cases. And then the people who operate there are people who understand the sector. One of the things that we are now currently looking at which I think is very important. When we train commissioners, we must introduce advanced programs, which also by election, people can choose to be trained on a specific sector.
Okay.
So that if you are deployed to a sector, you're already trained. All you need to do is to go and understand more than what we've trained. Rules that apply in bargaining councils, they're using our rules and they adapt them and then they become rules of the council. So there are no complications.
Yeah.
Unfair dismissal, they would add other things that are sector-based that you deal with there, right? So that's how it works, and that's the relationship that you have with the bargaining councils.
Do you find that some bargaining councils just struggle or fail and they have to refer to you?
Yes, there has been, yes. Yeah. Now we're dealing with the security one, where there are those type of issues, the challenges that are there, and those cases now we are doing them. At some point we had the Metal Bargaining Council that had struggles. We had to look at that type of intervention. So yes, it does happen. It's not often.
It's not common.
It's not common now, but it does happen. Yeah, it does happen.
Do you find fulfillment in this role, you personally?
Yes.
Do you, or more frustration? Yeah. Which one is it?
That too. It's both actually.
Yeah.
And my major frustrations is what I've explained earlier.
Yeah.
That. Maybe let me backtrack a little. I used to represent employers. I used to work in a consultant business.
So you know both sides.
I know both sides.
Yeah.
You know, so I would go with this. That's where my employment law experience and exposure started, actually. Okay. There was a company called Brahma Consultants. It was a man called, Chris Meyer, who really introduced me to employment law. And gave me an LRA, yes, Schedule 8, go and read it. We're going to do disciplinary hearings in the workplaces. And I read that. And at the time when I was studying law, I had no interest in labor law at all. I was more on civil and criminal law at the time. Many of us at the time, how it's like. It was fashionable to be a criminal lawyer, right? So when I was exposed, I started taking interest in that. So as we work, I was earning, by the way, about 600 Rand per month at the time.
Jeez.
Right? So
with a law degree?
I was not. I didn't have a degree yet.
Okay.
That I was still studying.
Yeah.
So I would go to places because I was trained to do disciplinary hearings. In some cases, you do prosecution, and do all of that. And in the experience at that time, one of the things that I've learned was when an employer gives an instruction to dismiss whatever it takes, I could not handle that. I said, but what do you mean, whatever it takes? Fairness issue and all of that, what about that? I said, no, hell with that.
So that is common. Do you know, I've heard of whatever it takes. Dismiss whatever it takes.
Yeah, and I remember this one incident, which was not at the consultancy, and when I was in practice, that made me join the CCMA afterwards. I had a very good client, a very good paying client, right? And said to me, they had a serious problem of personnel because they were overstaffed.
Okay.
They did not even want to retrench. Workers made a mistake there. Right? And when you work there as a consultant and all of that. So they went on an unprotected strike. And they said, so do we dismiss? I said, no. There's processes and procedures to be followed. You can't do that. And I said, dude, this is our opportunity to correct our balance sheet. How do you correct the balance sheet?
Let's get rid of them.
Let's get rid of them. Then we re-employ people at a different salary scale.
Yes.
And I was like, oh, hell no. We're not going to do that. I said, well, we're not going to pay you if you don't do that. I said, then don't pay me.
What was your role in this case?
I was a consultant.
So you were should have been on their side.
Yeah, I should have been on their side. Yes. Not bring these equity issues that I'm talking about of fairness. That was not the question. The question was, this looks good. It's an opportunity. So go for a kill. I said, I'm not going for a kill. No, I'm not going to do that. We're going to engage. We're going to mediate. And I said, we don't have time for that. And this company is struggling, so we have to fix this. I said, no, then you better get somebody else to do it. Because I'm not going to do that. Then I said, then you're fired. I said, thank you. And yes, they did fire people. And then the condition of re-employment was re-employment, not reinstatement. Salaries change and all of that. So how do you go home and sleep with that?
So the condition was we hire, but we hire at lower scale.
Yes. And as if you're just being employed from today.
Jeez. And you've been here for 20 years.
Yeah. And you get your pension, everything, that's fine. There are people who are brutal and cold like that.
And that happens.
It happens, because I experienced it.
And you saying, well, your last statement in that regard, you said, how do you sleep?
How do you sleep when
Yeah.
you do that? Because just picture this. An opportunity, it's opportunistic, right? You balancing your balance sheet, but families go hungry.
True. And you're fine with that.
And I must be the one who does that.
Yeah.
Because I want to get paid because it's a good paying client. Said, no, I'm not going to do that. Sorry, I'm not going to do that. Right? That's how I lost a good contract.
Yes.
Right? Somebody else came and did it. And
Of course,
they moved
there'll
on.
always be someone.
Yeah. And then I said, you know what, hell with this. And then I joined Union in Nehao at the time. And I said, now
So now
here
you're
I'm on the
representing
other
the
side.
workers.
Now I'm going to fight.
Yeah.
This one, if I win, I sleep peacefully. When I save a job, I sleep peacefully.
That's true.
When you represent a worker and you are the union official, you travel to their houses. You sit down, you see the poverty that they go through and the effect of unfair dismissal.
Yeah.
You see it live, right? I'm not painting that everyone and every company does that they're just indiscriminately. No, I'm not saying that. I'm saying that in my experience, I did see that. But when I was at the union and I represent a family, remember, you don't represent a worker. And you're sitting there, they don't even have food. Can I buy food for tonight as we're consulting because you're condescending? Until they say, if there was something else we could do. I said, but on the side, I can help in the meantime. Like, can we buy something? So, yeah, sure. Then I give to the worker the money. I said, here's 100 rand, go buy vegetables, they buy poofu, they buy.
While we're talking, bazape.
Yeah. And then when you came back, I'm like, 10 rand, 15 rand, done. While you're sitting there, the stove is starting the uksebenza.
So you can see
the reality,
poverty.
the real face of the effect of a dismissal.
Yeah.
One thing we never track post-dismissal is what the effect of dismissal is. Yeah. In reality, I'm not talking about you're unemployed, you lost this. Yes, you lost income, but check loss of income and the effect of that, what that is. Then when you work for a union like I did, right? And that's what gave me complete satisfaction. I will go and sit in the house there. And then by in the stove, after cooking and everything else is done, right? And then later.
Yeah, then you can see.
I'm sitting there and look at the face of those children when food is put on the table at that time. And that gave me the fire inside to be a best lawyer to represent him with that. When I sit and argue, I have fire burning in my eyes.
True.
Because I know who I represent. And success for me there means that this man can provide for his family when he's back at work. You understand the content of your representation.
That's true.
And when I go to sleep and I know they're eating, I know he's got employment, why wouldn't I sleep like a king? I'm not saying that when you make a decision, when we're instructed to act in terms of that ends in dismissal is a bad thing to do. I'm talking my personal experience. That drove me to the union. That drove me to come to the CCMA. When I come here, it's about equity. It's about fairness.
True.
That's the constitutional value. That's the constitutional drive. Why wouldn't you sleep if you achieve equity?
Fairness.
Why wouldn't you sleep if you achieve fairness? When you achieve healing, as the Constitution says.
That's true.
Because to me, the history we come from, the rate of unemployment, the level of illegitimate dismissal as they happen, the level of unfairness that you see, and all of those kinds of things, we need to fix it.
Did you notice a spike of unfair dismissals as a result of COVID? And it's a perception. Maybe it's wrong. When it was also an opportunity to fix the balance sheet.
The balance sheet.
And here's a chance to retrench. Because there was a number of retrenchments during that time.
Yes, they did.
Or what did you notice?
Yes, they did.
Yeah.
There were a number of retrenchments during that time.
Yeah.
There were quite complex legal questions that arose.
Yeah.
You see, when you've got a contract of employment or any other contract, there must be possibility of performance.
Of course.
You can't enter into a contract if it's impossible to execute. It's one of the basic requirements of a valid contract. Possibility of performance, right? So, but there's always this supervening impossibility, we call it in law. And COVID was one.
The unexpected, act of God.
Unplanned, an act of God, the vis major, they call it, right? So then at that time, some of the workplaces started using that argument that says, firstly, we may not dismiss you, but we will not pay you.
Yeah, because you're not working.
First, you're not offering service. And it's not the employer's fault. It's the act of God, right? If you don't accept that, then we're retrenching you. Some were retrenched using an SMS. We can't call you to the hearing. It was even before this online became fashionable. Somebody comes with a WhatsApp. They said, we can't afford it because the company has not been making any production, so we have to dismiss. It's contained in an SMS, contained in a WhatsApp.
What?
The supervening impossibility, then the contract then comes to an end because we are unable to perform it because of COVID.
Yes.
I then, at some point, asked the following questions. Is there impossibility? Did COVID cause impossibility?
What answer do you get?
Here are the two scenarios.
Yeah.
If you have floods, if you have wildfire, that destroyed properties, that kills people, right? I can understand that. But COVID, while it was killing people, it was not killing everyone.
And it was not killing everything.
It was not killing everything. Buildings and everything was operating.
Yeah.
But there was no flow of business not because of COVID per se, that it's in the streets and blocking, causing death. It's because we legislated.
True. Yes.
We legislated, right? So legislation stopped movement. Level 5. You can't move.
Yeah.
But it never said you can't do online work. CCMA continued to work, by the way, during that time.
You had challenges, though.
We had serious challenges. Very serious challenges at that time.
It's well documented.
It's well documented during that time, right?
Yeah.
So issues that related to dismissals relating to COVID, unfavorable practice relating to COVID became rife at that time.
Yeah.
Others said, I don't have gadgets, so I can't come. So I want to come to. So you must be an essential service to do so. So if you are found on the streets, you're going to get arrested.
Yes.
So our
legislature
our caseload dropped significantly.
Okay.
But it did not mean there were no unfair dismissals.
Sure.
Because people who use, coffee shops and to refer, they can't refer disputes. So many disputes happened, but they could not be referred.
Yeah.
So when doors were open, then they started flowing.
You had a flood.
And you still had to deal with condonation because by law, it's late. Despite the fact it was caused by COVID.
You were dismissed in March. And now it's
after
June.
30 days.
It's June.
Yeah, and then you say, said, well, you're late. So, but we were dying with COVID, but that's the reason you should put in the condonation application.
Do that.
Do that.
Yeah.
Then we understand, we know. But by law, you've got to explain that. Reason for late, regulation said we can't. Then it's understandable. We can't punish you with that.
There were a number of very dynamic cases during COVID of dismissal. Quite a number of. So there were a lot of new learnings and vaccination issues. And I don't want to vaccinate. They want me to vaccinate. You were dealing with a lot.
It was hectic. And at that time, there was hunger in the labor market to find legal certainty whether you can dismiss an employee who refuses to vaccinate.
Yeah.
And they were not getting to the labor court. Almost all the cases we found were settled.
Really?
Yeah. Our settlement rate on vaccination cases was quite high.
Who was proposing the settlement?
It varied.
Yes.
It varied. Some of them ended up at court, by the way. There was one or two that ended up in court.
There is a big one that ended up in court.
In court.
Yeah.
But those that came, I remember I handled about a few, and one of them involved a law firm of a candidate attorney who used his constitutional right to safety and everything else, and that he doesn't know, body integrity, does not want to vaccinate. We found ourselves in a very unfamiliar territory on now all of a sudden we have to apply constitution to the core and policies. And one of the bigger challenges at that time was because government was producing regulations like
on a daily basis.
Yeah. And now you had to keep up with those amendments so that you know what's the latest and be able to teach, but you can't walk, you are on level 4. And then the president showed there's a family meeting. Oh, we're back to level 4. We're back to level 3.
Which has different implications.
Different implication its own. Others were dealt with because of violation of all of those kinds of things.
You guys were busy.
That was the most busiest time. Even our meetings took longer. That's when we started feeling for the first time the effect of online meetings sitting there from 9 till 12 in the evening.
The whole
because we are
day.
in the house.
Yes.
And it continues to do so. Our commissioners had essential services certificate that we issued. Get stopped by police, we get a phone call. Do you know David? Yeah.
Now,
he says he's working for you and what? And then you answer that, they get released. It got seriously complicated. It was a special scenario
What?
at that time.
But were there lots of lessons?
A lot.
Yeah.
We need to be really prepared for the next wave whenever it comes.
Or whatever it is.
Whatever it is, that it could be something different at that time. Firstly, we learn how dynamic and versatile we should be in the workplace. Not be fixed in the traditional way of work and brick and mortar approach. That's important. 2, the significance of remote work. The significance of remote or online dispute resolution, we call it. And it became to life. Basically, 4IR was imposed at that time.
Yeah.
Companies started developing alternative methods of work and said, well, if we had AI and if we have automated systems, we wouldn't worry about work. We'll continue with production.
We can see them that they're working.
Yes.
Yeah.
And then it expedited creativity and innovation in the different
Kicking
workplaces.
and screaming, we had to adapt.
Kankani.
Yes.
We had to do that, right?
Yeah.
While fearing death and disability. As we're sitting here today, I ask myself, what happened to COVID? It was fashionable and people dying. Today we get flu. It could be COVID, you don't even know.
True.
But no one is running away from me
No.
because I've got COVID.
It was the same thing with flu when it became a disease.
You remember?
There was when you look at the history of
What is swine flu?
Oh yeah. They speak of all that we used to run away and now we're good.
And when we started seeing prominent people dying, because those who had perception that no, this is fake, then you realize, and like HIV, this thing, it's real. And it really does. It tested also our Occupational Health and Safety Act.
Oh yes.
It tested Compensation Act.
Sure.
That you make provision for things you never planned for and creating new jurisdictions. So there's a host of those lessons. But as we always do sometimes, when we confronted by that, we react to an emergency. Post the emergency, we get to relax.
Yeah.
Waiting for the next disaster.
And that's when we should be getting ready.
This is the time we should be doing it. The same thing with water issues, right?
It's a human problem.
We're sitting here in Gauteng. We don't have Cape Town. Do you remember Cape Town? The zero thing.
Yes.
Now, Nelson Mandela is going through the same thing.
I remember in Cape Town, they used to have, if you walk into a toilet, you'd find the words, if it's yellow, don't flush it. If it's brown, maybe you should consider flushing.
You can't even shower.
Yes.
And bathtubs were closed. The prop, they remove it because you can't use it without that.
That's it.
But we adapted to it.
But while it's quiet, we don't work hard to prepare for the next wave.
You see, like now, we've got torrential rains. We've got flash floods. Are we creating reserves to have enough water in case we go back to where we were? Because at some point, Johannesburg was approaching the same thing.
No.
We didn't think that Nelson Mandela will be going through that. We just worried about Cape Town. Cape Town has floods, has flash floods. They've got what? Are we creating storages now for that? Because now we're okay. The same thing with COVID and the challenges we've had. We create instinctive, responsive strategies, but not proactive ones.
Interesting. I want to change subject but one second. Before you came along as CCMA, because you were only established in 95.
Yes.
What was the scenario in the country? Of course, there was apartheid.
Yes, and all of that, yes.
Yes, but what was if I had a problem as an employer or an employee for that matter, what were my options?
Industrial courts.
Okay.
There were industrial courts at the time, conciliation boards, not in the way that it is now. You did have courts, particularly the industrial court. The very reason why CCMA was created was exactly the opposite what happened before that time.
Okay.
Courts are expensive, it's litigious, it breaks relationships, it takes long. And also the legal technicality issues. So that was an environment there. There were things created like the conciliation boards where people can conciliate, but not necessarily in the way that we're doing it. You did have other, IMSA institutions that were created at the time that existed that did all these kind of things, which then translated to what we are now.
Yeah.
So you did have that, but not at this scale. But litigation was was rife at that time. And also what was even more complicated is that you had a superior legislation, but the constitution inferior.
Okay.
Today we enjoy the opposite. We've got constitutional supremacy.
But the application
is something else.
Yeah.
Legislation is subject to. It's not that, because we had parliamentary sovereignty. We've got constitutional supremacy.
That's it, yeah.
So the institutions that existed did what they could then in terms of that setup, the legal framework that operated in at that time, right? And in terms of the old Labor Relations Act of 1956, and that dealt with things in the 1983 basic conditions at the time. So then it transformed to what we have now.
But I imagine at the heart of it, there was accepted discrimination.
Yeah. Of course, at that time it was lawful
to say kafir.
Yeah, and if
move
you are,
on.
where will you run to?
Yes.
And what law will you use to say that's wrong? It was accepted, it was permissible at the time,
Yeah.
because that's the system that had.
Yeah.
You didn't have Employment Equity Act at that time
Nothing.
that talks about unfair discrimination. You didn't have that. It's only now that you have that.
Yes.
You didn't have national minimum wage at that time. You had different legislations. In fact, in the olden days, unions were run by white people,
course.
by the way. And at the
Yes.
time, that's what. So now we look at today, it's the other way around. You wonder, where was the takeover, the baton?
It happened.
Where that, it was all race-based and all of those kind of things. So we need to look at that history, but not to repeat it, but to learn from it when we legislate, so that we enhance and do. Labor Court and CCMA are the best creations of democracy.
Yeah.
Make no mistake about that. Best creation. It's the success story of the LRA, that one, including the Employment Equity Act.
Yeah.
And you can't even imagine what it was like before
Jeez.
because of what we have now. Really, it was absolute excellence.
But it's only truly best if it serves the people it intends to serve.
It must.
Yes.
If I say that this is about protection of conditions of employment, it must do so.
Yeah.
If it's about protection against unfair dismissal and unfair labor practice, it must do so. We really have succeeded when it comes to unfair dismissal, unfair labor practices, and all of that. There are still many gaps that exist, especially in the context of employment equity as well. Because, for example, damages in the employment equity on what you can claim, it's limited. And I asked the question, why is it limited? Why are you capping my damages that I can claim?
Yes.
Is it because you're not trying to scare people to coming to courts, to the CCMA? We never had a body like a tribunal that has the power legally to grant damages. Now, CCMA can, but only in the context of Employment Equity Act. There's a lot to be grateful for. There's a lot of good successes because of the creation of the LRA and the creation of institutions that are created in terms of that.
Yeah.
But the gaps that we talk about,
I still found.
they are eating away the good that it's doing.
How do we deal with the gaps?
It's legal reform.
As South Africans watching this and saying, how do I, even if it's just not me personally, but how do the gaps, how do we overcome this as a society?
It's different levels.
Yeah.
At the top, it's legal reform. Because it's not just legal reform, it's the speed at which we do it.
Yeah.
And my biggest worry there, David, it's other than the issue of speed, is that all apartheid-related legislations that existed before democracy, you will find there's those that still exist because they will continue to exist until tested.
Of course. There's many.
Yes.
Yes.
So what systems do we have to check that which is unconstitutional be declared unconstitutional? How does a law survive in life support from before democracy to after democracy and continue to serve? That's an issue for me, right? So we need to have systems that identify such legislations. We need to put together systems that test effectiveness of legislations we've made.
It's almost like bodies who say, you look at that chapter.
Yeah.
And go spend 2 years.
Yes.
Analyze it, see its application.
Yes.
And then pretty much stress test it.
Yes. And if there's anything I can say in your question, we must encourage our fellow South Africans to increase the culture of learning, the culture of reading. Right? You can walk into a post office, you'll find a constitution.
It's everywhere.
But how many people do that? You go online, you'll find the constitution. you'll find the LRA. But how many of us, when you don't have a dispute, when you are not studying it by decision, that you take the employment equity and read it to understand what it's about? The culture of reading, we need to increase that, because the more we read, we get more informed. Then we will be able to raise the right questions about gaps of things that are good but not serving us fully the way it was intended.
True.
Right?
Because it hasn't been tested.
It hasn't been tested. Remember, when you create legislation or when you amend legislation, there's something we call a mischief. There's a reason why you create law. There's a reason why you're amending the law, right? When we've created the law based on that mischief, there must be a time for us to test whether the reason for which we created we've achieved or not. We need to find a structure and system, because we don't do that. We don't evaluate
We wait.
that. We wait. And I was hoping that at some point when we're discussing at NEDLAC, say, instead of us legislating as we legislate, can we create an instrument that tests the effectiveness of what we've created since 1995? Right? CCMA started operating in 1996 in November the 11th. Since we started, you can't evaluate our effectiveness by the number of cases that we are doing.
No.
That's one part. But if you look at the number of awards we've made, that's one part. The reinstatement and commitment, that's one part. But the actual legislation itself, when we said this is intended to prevent and deal with unfair dismissal, did we succeed
doing that?
in doing that? If we're not succeeding, where's the problem sitting? Or it's sitting with enforcement. So what's the problem with enforcement? So the Department of Labor enforces, CCMA enforces, the Labor Code enforces. So can we find an integrated approach of enforcement, for example? So if CCMA must enforce awards, how do they do it? So they must go to the sheriff to do so. Can CCMA have its own sheriff to enforce its own awards? Let's look at that. When we enforce, it's supposed to be free of charge. Are people paying for that? Yes, because now we've created, the department, and to which we're grateful, has created a fund that they give us to assist those that can enforce the awards to pay for their costs with the sheriffs. Right? But while we do that, if we are forced to do that, the employer who ought to have implemented that must pay the cost of execution.
That's it.
So that the fund can sustain.
So, but that came over time, not immediately.
Yes, it's intended to also assist the effectiveness of the legislation that we're talking about.
Here's one that needs a review.
Yes.
Trust me, it's not a personal case.
Yes.
They fall pregnant.
Yes.
He doesn't want the child. Not interested.
Yes.
I'm not ready. That could be a reason.
Yes.
I can't afford this child. That could be a reason. She wants the child. She wants to keep the child. She's happy with the child coming to life. And he's saying, don't ever call me about this child. Should the moment arrive when you need to pay for whatever, I told you I'm not interested. I told you why. Whether you accept my reasons or not is neither here nor there.
Yes.
But I don't want the child.
Yes.
The law says she has constitutional right to decide on life.
Correct.
Only she does.
Correct.
He doesn't.
Yes.
He can say, I don't want the child. But she can.
She can.
If you reverse the story, they fall pregnant. She doesn't want the child. He does.
She can terminate.
She can terminate. And the law allows her.
Yes.
And even on the other side, the law gives her full right to life. Loophole. Where's the guy in the picture? That hasn't been tested.
No. In fact, it starts with the issue of bodily integrity. Because a woman bears the child.
That's it.
And everything else and complications and pain that comes with it. But it doesn't happen itself. There's a contributor, right? So it's about issue of balance of interest and a balance of rights there. It is indeed a gap there. So if you say that I must enjoy the equal, it's the same thing as maternity and paternity issue. So maternity you can have 4 or 6 months, but I'll teach 20 days sharp.
Yes.
That paternity, that's how far you go. The balancing between that.
Same.
Right? So the same question here, we need to check international standard. Is there anywhere else in the world
where this has been tested?
Where has been tested and practiced differently. Why am I saying that? It's because our Constitution obliges us in the interpretation of law and the Constitution and the development of our common law, you must have regard to international law. We sign and ratify conventions and bind ourselves to those standards.
To the rest of the world.
The rest of the world.
Yeah.
So if there is a gap and the imbalance in terms of the exercise of rights or competing rights, because we're talking paternity and maternity rights,
True.
right? So what are the international standards where, when faced with this is what they provided to resolve the issue?
Yeah.
But unfortunately, it's not even that straightforward, because cultures are different.
That's
the economies
it.
are different.
Yes.
And there's a huge difference when it comes to that. So the application and content will also be different. But the idea why we look at international standards is to pick what we need that can assist us and apply it domestically.
That's true.
In order to achieve the balance between the two. So we need to resort to international instruments if we don't have domestic assistance in that regard.
Do you do that as a CCMA?
Do what?
Does it matter to you what happens in the rest of the world when it comes to labor relation issues?
It's a constant. Let me answer it the best possible way. South Africa has ratified many conventions that are produced by ILO, right? Including the one that Solidarity challenged, the Convention 111 that deals with unfair discrimination. Because we are signatory or ratified that convention, and the decisions that are made in terms of unfair discrimination cases where we have jurisdiction, we get tested by international standards. So in resolving a domestic dispute using international instruments, because it's a constitutional obligation, we are international.
Yes.
Right? So CCMA, therefore, in interpreting the law, in the application of the law, and the declaration of such disputes, we are participating in an international environment.
Yeah.
So we do have an obligation to apply international standards. With domestic work, collective bargaining, there's plenty of them, including essential services, all of those. If you look at the judgment of the Labour Appeal Court, including labour courts, especially the Constitutional Court, they will never make the mistake of not looking beyond our borders in solving domestic legal issues because of the obligations that we've created. To get it right, you've got to do it right the first time.
Yeah.
Meaning when I'm sitting with a case, evaluating the evidence, get to the analysis of the facts and law and the application of law, I must not be oblivious of the international standards, especially on questions that are unanswered. If you look at the case that deals with the labor brokers, the assigned services judgment, and many of them, but particularly that one, you will see, especially the LAC judgment, it evaluated international instruments, the Namibian approach, how do they deal with it in other countries? And then you check on those, what can I take as a best practice in resolving the disputes? If the courts can adopt that approach, get it right the first time, and do the same at arbitration level, which includes international standards. And we attended a conference now a month ago at the ILO for 2 weeks, where development of conventions is made. In fact, there's a new definition of social justice there by the General Secretary of the ILO that has 4 dimensions, including that when you're talking social justice, it's a human rights issue. Talking about issue of just transition, issue of social protections, it becomes the new ingredient. So we have to domesticate that content. But it is operating at that international standard, and we bring it here to domesticate it and applying that. So we wouldn't attend ILO
if you are not an international animal.
Exactly.
Yes.
Exactly. We attended because we are an international animal.
You very recently, and this is us wrapping up because we are on 4 hours now.
Yes.
You have changed the rules.
Yes.
Some of the rules
at the CCMA. Yes.
At the CCMA in the past, 2-3 months or so?
Yes.
Yeah. What are some of the most basic changes that you've applied and why?
Number 1 is to accommodate online hearings.
Okay.
This is now the remnants of COVID.
That's it.
Right? So that you can do a case online, you can refer online. We've developed applications or apps for you to check your cases. We've got websites where you can click and refer cases online. Now we've even developed an e-commissioner, electronic commissioner, and we didn't make provision for that in the rules prior. So now it's now in the rules. So you can use the different platforms to refer disputes and do disputes in that way. In addition to that, we've also getting rid of old things, such as faxes, for example.
Okay.
Fax is old. Even though there's one part that is still remaining. I mean, can you imagine you're still sending a fax today?
When was the last time you got a fax?
Yes. No, I don't even remember the last time I used a fax. You know, one of the problems with the fax is that some people are naughty. When they are late or they're not ready to bring it up, they just push in blank document. It's like I'm only blank. But no, it's upside down. You know, but the fax report shows I refer the wrong time. So we're getting rid of the old things.
Yeah.
The other part which is important is the issue of simplicity.
Okay.
For example, we had a rule where if you refer a case on time and your referral is incomplete, you ought to have applied for condonation and you didn't. We would panned that case. And as it's sitting not going, then it start creating more time. Say, but this is not right.
Okay.
Right? So when you refer on time, even if there are things that are missing, but the referral was done on time. So that sorts out a lot of problems associated with that. The other issue that we've changed, which is important, relates to subpoenas, right? Because people can just subpoena anyone, even if there's no reason. You know other people, what they do? Because they're pissed off for whatever reason at the workplace. And then instead of to subpoena someone who's relevant to testify in your hearing, they subpoena the whole board. They subpoena managers and executives because you can.
That's being naughty.
And you can't oppose it at the time because it was just the applicant and comes to us, we evaluate, we make a decision. I said, no, the Audi principle says you must hear the other side.
True.
So let's balance
Audi altram patran. Yeah. It's the only phrase I know in Latin. Only one.
Yeah. So let's balance the equation.
Actually, no, mutatis mutandis, but I forgot what that means.
With the necessary changes.
Oh, there you go.
That's what it means, yeah. So we brought that,
yeah,
right? And we sorted that out. Yeah. And the other issues was about postponements.
Okay.
We learned that from cases, right? And said, if you apply for postponement and you agree, right? We said the agreement must be in writing.
Okay.
And if it was not in writing, one party agrees and it's in writing, but the other one did not sign, then we dismiss the application on the basis. That's wrong.
Got you.
We can't be doing that, right? Yeah. So even if it's agreed, now we accept any form of proof. You can show us that, look, Sheba, in writing, here's WhatsApps.
Okay,
we postpone agreed, and it's agreed, done.
Yeah.
All we need is there must be written proof that parties have agreed. So that simplifies the process. So in the main, those are the changes that we've made.
There's also a protection of personal information issues.
POPIA.
Yeah.
Yes. That one is an obligation of everybody. We were quite hit by that legislation because we deal with people's personal information.
True, when they complete forms.
They complete form, you add your address, you add the address of the other side, you also include, ID numbers, you do. That's personal information.
That's
and
true.
People tend to abuse personal information, right? So in part, we're happy with it because it's protecting people's personal information. But it affects how we work. So if I issue a notice of set down, so what do I say now? Do I add the address? Do I need the other side to consent so that they can issue the referral? I don't add somebody's ID. If you don't, then we can't put that in the system. What we then did, we requested the information regulator to come and assist us. We said, look, we are different. I don't know how you dealt with the courts, but in our scenario, we can't do without this. We can't always seek consent, right? For us to process personal information and for the purpose of dispute.
And this person will say no.
And then what happens?
Yes.
Should the dispute stop?
I want to write you that you step on my toe.
Yeah.
And you say, no, you can't use my details.
No, you can't do that. And in fact, what was interesting is that in our rules amendment, the first part that starts with our new rules is POPIA.
Jeez.
That says, remember, we know this and this and that. We know what processing.
How did you resolve that, though?
No, we made a few adjustments on our referral forms. And also, the consent issue. Prior to referral, you can't control it.
Okay.
So you've got to do that. And fortunately, we've received, confirmation from the regulator that we are compliant.
Okay.
And I'm happy with that. But we still deal with personal information. Yeah.
This has been a thoroughly, I enjoyed this because it's a world that I don't know at all.
Yeah.
And yet we engage with it on a daily basis. Not only as employees, but also as employers.
Because you need to be informed.
You need to be informed. And one thing that for me that comes across very strongly in this conversation is the lack of knowledge.
Yeah.
That general,
That's key.
yes, and that's the general public, whether
Yes.
educated or not.
Yes.
Because they are the very employers who step on people's toes are highly educated,
Yeah.
but they find themselves in those situations where they did something wrong. Procedure issues tend to
Yes.
be a big factor that I came across
Correct.
in preparation of this, where
Yes.
a person did something wrong,
Yes.
they stole, but
Yes.
how they were dismissed,
Procedure
was
Is
an
key.
issue. Yes.
Yes.
And people win a case on
because you procedural fairness.
yes.
Yes, because you can lose a case because you, on grounds of procedural fairness, you didn't give him an opportunity and comply.
Yes.
Sometimes because the chairperson of the hearing is biased, for example, and all of those
Jeez.
kind of things. But that's part of procedure.
Quick questions.
Yes.
Can I bring a case to CCMA as a collective? We
Yes,
were both dismissed for the same thing.
yes,
We can.
yes, you can. Well, how you do it is that, firstly, it's like David and 15 others.
Okay.
Right?
Oh.
Yeah, that's how you
Okay.
refer it.
Okay.
But together with that, you attach the list and signatures of those that are part of the dispute, so that when an outcome is made, somebody cannot come on his own later on and say, no, I was not part of that because they lost the case. Now
So
you want to
there
have a
has to
second
be
part in the
agreement.
cherry. Yeah, that we are part. And when you say who are the parties, when it says is David and 20 others, but we must know who the 20 others are.
yes.
They must also consent that this is their dispute, so that when the matter proceeds, they'll be bound by the outcome and they can participate.
Done.
And when we execute, you can't have a second bite to the cherry because you didn't like the first outcome.
Do you know when you said David and others, I saw Brenda Vaz and the big dudes. I couldn't help myself. And then my brain said, okay, if I go international, I saw Gladys Knight and the Pips. It's the DJ in me. I couldn't help it. What other question do I have? Quick question related to
Yes.
legal representation.
Yes.
Can I be represented by a lawyer in a CCMA
Yes, you can.
procedure?
It depends on the dispute. There's different parts.
Okay.
If there's a jurisdictional issue before the process starts, legal representation is fine, is allowed. There's no issue
Okay.
there. A retrenchment issue, you can be represented. Unfair labor practice, you can be represented. Unfair discrimination,
I
you
can
can
be
be represented by
represented.
the attorney.
Yeah.
In misconduct cases,
Where I've done.
where it is based on misconduct,
Yeah.
it's not automatic.
Okay.
You have to apply for legal representation. And that's the Rule 25 part.
Mm.
Then to show why complexity and all of those kinds of things and the requirements of Rule 25 on why you need to be represented by a legal practitioner. Even candidate attorneys now have a right to appear. It's not just
Wow.
for legal practitioners. Yes.
Yes.
So you do apply on misconduct matters for you to be represented by a legal practitioner. But the others that I've just listed, yes, there's no application required. You go straight in that.
In a company organogram that has, board,
Yeah.
CEO, and everybody else, can CCMA look into cases related to everyone in that, including from as high as the chairman of the board to as low as a worker or a guy at the gate who's letting cars in?
For as long as you're an employee, yes.
Yeah.
That's the first test. You've got to be an employee. If you're a board member, but you're not an executive board member, you can't appear.
You can.
But if you're an executive director, because it means you're a board member, but also you are an employee.
An employee.
Like the director of the CCMA, for example.
Yes.
By law, you are an ex-official member of the board.
That's it. Yes.
But at the same time, you are an employee.
Yeah.
So if I get dismissed, I go to the CCMA.
That's funny. I wonder how would you manage that?
Yeah, it's quite interesting, isn't it? Yeah, I tell them I'll take you to the CCMA, but I'm the director.
And how would you deal with that? Your commissioners will be like, how do we deal with this guy?
Yeah, that would be quite complex, right?
Rather. Wow, we should test that.
Yeah. Not by dismissing me first.
No. Does it cost money to use the services of the CCMA?
No, our services are for free.
Yeah.
The only exception is when an employee, in terms of an agreed contract, who is below a threshold, right? It's agreed that if there's a dispute, it must be referred to the CCMA. It's called the Section 188A dispute.
Okay.
It's a disciplinary part in an arbitration sense, right?
Yeah.
For that, we charge.
Why do you see the need to charge for that?
Because a disciplinary is what you should be doing in your workplace, not at the CCMA.
Ah.
Yes, but the beauty of it is that, the challenges that you have in disciplinary hearings, the complaints that the employer chooses who presides.
Of course.
So it can't be fair.
So do you see that as a problem?
No, it is a problem. It is a problem because in many cases, if you look at the challenge on procedural fairness, it's about the chairperson of the DC.
Yes.
That the chairperson was biased, the chairperson was unfair, he excluded the following evidence and all of that. He's paid by the employer. You get all of those kinds of complaints. But if it's the arbitrator sitting and I'm under the auspices of the commission, not your employer, the employer can't tell me anything.
No.
They're a party to the proceedings. They must present evidence.
Yeah.
When the award is issued, the advantage of that, when the award is issued, it's not dealt with by the CCMA afterwards. It goes to the labor court. But if you do a DC in the workplace, you get dismissed there. It comes to the CCMA. Right? It's another stage. You're repeating it again afresh. The whole process, right? So we do with that afresh. If you're not happy, then it goes to the labor court after that.
Who are you charging? The employer?
The employer is charging an employee.
Yes.
Yes, they will charge you, but to run the hearing, it comes to us.
That's it, yeah.
But you pay us a fee per day for us to run it for you.
Is it an affordable fee? Is it the
about
same
4,000
fee?
rand or so per day, yeah.
Yeah.
The employer pays for it.
It's not small.
Yeah, but it's the employer who pays.
It's not the employee.
Yeah, no, it's not the employee.
Because there's no way the employee will afford that.
No, they won't even agree to that.
No.
Reasonably, you'll run out of pocket doing that.
Do you pick up the fact that most of these big corporates, even small, because they run the entire company. You come in as an employee, you've done something wrong, all right, they're just dismissing you. The fact that they are the ones who are in control of the disciplinary process by inherently places the employee in a disadvantaged position. Is it as obvious as it sounds?
It's not as obvious.
Yeah.
Because otherwise, the process I'm talking about, it used to be called pre-dismissal.
Okay.
So on the face of it, it says that you are going to dismiss me. It's just a process prior.
Okay.
So they changed the name to,
disciplinary.
Inquired by an arbitrator.
Okay.
That's the new name.
Yeah.
Right? So on the face of it, if I'm an employer, I'm the one who appointed the prosecutor. I'm the one who appointed the chairperson of the
Not
hearing.
only appointed, paid.
And paid also.
Yes.
On the face of it, it's unfair. But it's not in all cases where it is unfair. Okay. There are cases where I have appeared and represent an employee and where outcomes were in my favor in the employee because there was fairness. It also depends on the integrity of the person who's appointed as a chair.
Yeah.
You must be like I did and said, dismiss people, or hell no, I'm not going to do that. Right? I'd rather lose money but be at peace with my soul. So if I'm a practitioner, an advocate, or I'm an attorney, and you say, do this disciplinary, I accept. And then you tell me, you must dismiss him. So asiyeke.
Yeah, there's no point.
Do you want me to make a decision or you want to make a decision and using me?
Sure.
So let me run with it.
But not everyone is like you in that
Not
case.
everyone will do that.
Yes.
Absolutely. Not everyone is like that.
Yeah.
There are many complaints where the subject of complaint is exactly that.
It's process, it's procedure.
Yeah, I said, no, but akukho siyakhona. And then even in some cases, when you say, I'm not ready to do the DC, but we're starting in 1 hour. What do? You can't run away. You have to do it. Otherwise, they'll dismiss you in absence.
It leads us to another question. How much time should you be given when, say, you're dismissed to when the DC is supposed to happen? There must be a lead time.
From charging, generally, it's 48 hours from charging to do a hearing.
Preparation
is 48, but, depending on the size.
Of course.
If it's the CEO who's charged because he ran the company to the ground, you can't prepare in 2 days.
No.
In some cases, it's much bigger, it's financial. Others is more complex. So it depends on the dispute, the kind of dispute that we're talking about in terms of the time it prepares. You cannot say for sure how much time is enough because it depends on the nature of the dispute and also the quality of the person who's representing.
How do you assign a case to a commissioner, you as a CCMA?
All commissioners who are trained to do unfair dismissal, we allocate them.
Can be anyone on any case?
Can be anyone on any case who is a commissioner.
Of course.
But we do have specialist fields like employment equity, for example. You got to be trained as an employment equity commissioner to do equity cases. We don't allocate you if you didn't train.
Yes, you must be.
No, you must
knowledgeable.
Be trained you must be trained in unfair discrimination cases for us to allocate it. But other than that, like essential services, for example, for you to go and mediate or conciliate that dispute, you must have been trained as such and be in that panel for us to give you that. If it's about demarcation cases, which are quite complex, you must be trained on demarcation cases to do so. So we don't just allocate in those areas. But other than the specialist field, everybody can do the other cases. So we just appoint for as long as you're a commissioner.
Quick question. I got a final letter of dismissal. It's not a dismissal yet. It's the intention is clear. Can I bring that through only when I've been dismissed? Can I say I'm not happy with this letter?
No, you can't.
Yeah.
The reason why you're coming to us, if it's a misconduct issue, is that you have been dismissed.
Okay.
You can't bring it because there's a possibility that you could be dismissed.
Yeah.
Because the first thing in terms of the LRA that you must prove is that you were dismissed.
But I'm not. Okay. It's not dismissal. It's a. Let me explain it in the way I understand it. The company is not happy with my conduct at all, and they've given me all sorts of warning letters.
Yes.
I'm dealing with another warning letter.
Yes.
I think I did absolutely nothing wrong.
Yes.
I came late because I was stuck in traffic.
Yes.
And they gave me a letter. It's a warning.
Yes.
I think it's an unfair warning.
Yes.
Can I say go to CCMA?
Yes, you can. It's an unfair labor practice.
Okay.
And said that the warning that was issued to me is unfair.
We don't wait for dismissal.
No.
Yes.
No. Even if you're demoted, you can refer an unfair labor practice.
Okay.
Right? If you are suspended and you feel that, for example, you're suspended without pay, but they were investigating before the DC happens, it's an unfair labor practice.
Yeah.
So you can refer that. It doesn't have to be dismissal first. You can refer an unfair labor practice dispute because of an unfair warning.
Yes. You don't wait for disaster.
No, you can.
Yeah.
No, it's section 186, subsection 2. Yeah, you can.
Jeez, you know them like...
Oh, yeah.
Okaru murutu wa kereke. I was like Jonas verse 4. You do it so well. It's actually quite impressive. What is a con-arb? In your answer, you give the entire thing. Okay. Yeah. What is the con-arb?
Thanks for that question. It's a very important question because there's a judgment actually that was issued by Judge Tshwane relating to con-arb.
Yeah.
Right?
What is con-arb?
Con-arb is a combination of two things: the conciliation and the arbitration.
Okay. Gotcha.
In the past, before con-arb was created, you only have a conciliation. So when you refer a dispute, you refer it for conciliation first.
Okay.
So within 30 days of your dismissal, you must refer a dispute. So we receive it, right? And then we set it down. Within 30 days, we do conciliation. If it fails, we then issue a certificate of non-resolution. It was not resolved.
Yeah.
Then you have 90 days to refer for arbitration.
Next step.
That's the next step, right?
Yeah.
So because of the time wasting from conciliation and then you refer again, you have 90 days and then it gets set down. So there's time wasted. Because the LRA is built on expedition, then they decided to bring the two processes together.
Okay.
Because an employee could choose that I refer it as a con-arb. So what is the expectation? The expectation is that if you refer this dispute as a con-arb, the commissioner who's appointed will start first by conciliating.
Okay.
If conciliation is not successful, we then proceed with the arbitration.
No waiting period.
No waiting period.
Yeah.
The idea was expedition.
Yeah.
That was the whole idea why it was created.
Yeah.
Right? I'll tell you why I feel passionate about that. But then there was a fix or a trick where the law created a right of objection. Okay. In other words, if I receive it as an employer that you applied for con-arb, which is the two processes joined, right? I can object.
Okay.
I object. So what is the objecting about? The objection is I object in arbitration starting immediately after conciliation.
You want a gap.
So there must be a separation. Basically, you're taking us back before the amendment happened.
Got you.
That's the essence why it's created like that. There's an exception though. If it's relating to probation, you can't object. So it continues. So there's no issue there.
Yeah.
That the critical thing that I wanted to bring up. I remember when I came for interview, when I became a commissioner the very first time. It was at the time when this was still an amendment.
Okay.
At that time, during the interview, they asked me what you're asking me now. Do you know what a con-arb is? And I said, you want the short version or the long version? Right? So what it was at the time, there was a proposal at the time that if you're going to lodge an objection, right, in terms of Rule 17, if you're going to lodge an objection, you must give reasons. The reasons which were provided in the bill at the time, it was the same reasons that you find in Rule 25. That talked about the complexity of the matter, the questions of law involved, conflict, all of those kinds of requirements, they were there. But when eventually it passed, those requirements were removed. So today, as we're sitting here, you can object 7 days before, lodge your objection that I do not want arbitration to start immediately. And you don't have to give reasons.
Okay.
All you have to say, I object to arbitration or to Con-arb.
And that gives it 7 days.
It separates. You do that 7 days before the hearing.
No longer 90 days.
No, 90 days is different.
Yes.
90 days is when it's an unfair labor practice, or the arbitration after conciliation.
Yes.
You had to refer specifically for arbitration after conciliation. So you had 90 days to do it. Right? So in this case now, you are objecting that it should not start immediately. So if there's an objection, you separate the two. One of the important decisions we've made also is that where there's a separation of the two, when it was referred initially as a Con-arb, there's no need to apply for arbitration because it was already there.
True.
So applying for arbitration, because that's what we used to do. And when I said, no, guys, this can't be correct.
It adds an extra administrative
process.
process.
What the Act trying to avoid in the past, now we're doing it here. Right? So then, immediately after that, so we must set it down for arbitration. Usually, when that separation happens, so only conciliation happens. If it doesn't succeed, so then we wait for the arbitration date for that to proceed. So then the issue now is that because you can't give reasons, which is what she's complaining about, is that you can just say, I object without giving reason, we're back to square one. It's frustrating the very principle of expedition that is contained in Section 138 that said we must do it quickly. It can't be quick if then you just object
for no reason.
Even if you have no reason to do so. You can send a receptionist to go there and sit there as an employee, and even if it's an executive on the other side, they said, do you object? Yes. I object. I sent that 7 days ago. She doesn't have to explain anything. That's it. That's the end of the process.
So how are you overcoming this then?
We can't overcome it because that's the law. There's no, in fact, the judgment that we're talking about, there was a case where a person objected, but the objection came less than 7 days. Okay. Right? And that was an issue. Is that, okay, now because it's that, so that objection doesn't hold, so I'm proceeding with the hearing. The judge said, no, he can object anytime because the issue of 7 days is in the rule, but it's not in the Act. The Act just says you can object. So you can do that indiscriminately. The moment I receive Con-arb, 7 days before the hearing, I object. Separates the processes, no reasons given. It does frustrate the issue of expedition.
Who does it disadvantage in this context?
Basically, it's the employee. Remember, you are the one who is unemployed. You are the one who's referring the dispute.
Now the
law says I can do it quicker by combining the two processes. The employer says, no, I object. Then it separates the processes. Then you're not ready. We used to have a form where an employee himself can just say, I don't want conciliation arbitration to start after. I'm not sure why one does that, because the sooner you resolve this thing, the better. Why would you want to delay that? If you're not ready at the time, you can always agree with the postponement on a mutually acceptable date and then do an arbitration at that time. But that's the frustration that comes with that.
Crazy. I remembered another loophole.
Yes.
In the law.
Yes.
Auditor General not being empowered to make bigger decisions than just finding the facts.
Yes.
They walk into your office as CCMA, they audit, they find manyofonyof.
Yes.
All they can do is just write.
Yes.
Or we found manyofonyof.
Yes.
And that's it.
There's an additional power that they have now.
However, I'll tell you now that the Auditor General says, I didn't go to school to prosecute. But
no, they don't.
Yeah.
They don't. The power that they have, which it's contained in the Act, they can in fact refer outcomes to the Hawks, for example, refer to the police for further investigation and also prosecution if need be. So they've got that power. The other power, which is the stinging one that they have, if there's cases, for example, of irregular expenditure and all of that, and they issue a directive that you should in fact act and deal with it, and you fail to do so, they can issue what they call the certificate of debt, that you, as a CEO, ought to have acted, you must pay for it.
Yes.
Yes,
that's good. That's good power.
They've got power. They can do that. It's contained in the amendment.
Yeah.
We were actually a candidate of that in terms of they were evaluating that too. That if we have found that you messed up in this is the process we're going to follow. And the board and
so they subject the CCMA.
Yeah, not that we did something wrong. No.
Yes, they say
if they found they could have.
Yeah.
If we fail to act on irregular expenditures,
things like
that.
But
they don't just do it willy-nilly.
Of course,
there's certain system they allow you and give an opportunity to act, and they tell you that you're failing.
Yeah.
But if all of that is done and we are still failing, then they issue the certificate of debt. Now you must pay it from your personal pocket.
As a senior,
CEO, the board and the CEO, yeah.
Incredible.
Yeah, because remember, in terms of the PFMA, you have a duty to prevent irregular expenditure.
If it happened under your
watch and you fail to take action, they're not just punishing you because it happened. It's because of failure to act.
Yeah.
Even when you become aware they told you failed to act, then they can punish you with a certificate of debt.
It's a Stina Dairy Farm. It's a VBS. We can go on. This was a lot of fun. Thank you so much.
No, thank you very much for having me.
Is there anyone in your office that knows this stuff better than you?
I've got commissioners that that knows better than me, I suppose.
That know this Bible.
Yeah, no, look, employment law for me has been a lifestyle.
Yeah.
And the good thing that I've studied it also, and I'm studying it at master's level, I'm studying now at doctoral level.
Yes.
So I prefer the higher levels, but knowing it must be second nature. If you say, okay, if I want to refer, what section do I use? No, you use section 191.
Yeah.
Oh, so if I want to prove the date of this section 190, you want to have owner section 192.
Jeez.
If I need issues of remedies, section 193, compensation, section 194, issue of labor brokers, section 198, A to D, dispute, you can do dismissal 180. You've got to have it in the system.
Yeah.
But know the content also.
Of course.
And then so that you must have ready knowledge to answer.
Yeah.
So that when you ask me a question, already I know where it belongs. Right? I'm just waiting.
It's.
I'm just waiting to finish.
Yeah.
When you're done, I give you the answer.
Okay.
Because
the law is black and white.
It is, and you have to know not only just the statute, but you have to know the judgments made that interpret what you're talking about.
Yeah.
Because that's the most important part. Because if you just know the statute, you just know half the story. Because the courts would have interpreted in terms of actually this is what it means, without just literally reading what it means.
Yeah.
So if you ask me if there's a tripartite of issues relating to labor brokers, whether an employee can be employed on indefinite basis, yes, 198A, that's what it's about. You need a tripartite.
You find the application.
Application, assigned judgment, decided this is how it looks like. Even the question that she asked me, there's a judgment to it that came, and this is what the court held, that you can't do, this is what you can do. But you have to get it into your system. You have to do it regularly.
Yeah.
That's what we meant by the culture of reading, the culture of learning.
Yeah.
Even if I'm not studying anything, even if I don't have a case against me,
you just read
just take it and read it.
Yeah. And it stays in your mind.
Oh God, what does section 186 is about? Oh, it's about the meaning of dismissal. Oh, then there's a list of that. So this is what it means and all of that. No, that's fine.
Yeah.
Just casually reading it. The same way if you read Daily Sun. Do the same and take in labor relations, I can do exactly the same thing.
Daily Sun is fun. Do you enjoy it? You seem like you do.
I really love it.
Yeah.
I really do. Together with that, administrative law, constitutional litigation, that comes with it. Because it is equity based.
Yes.
And there's nothing more sweeter than resolving a dispute. It's really sweet. And especially in cases where both parties feel like winners.
Yes.
That it's a mutually beneficial outcome to both parties. It is the best thing ever.
Jeez.
And it is a global subject also. So yes, I do enjoy it. Yeah.
What else would you do if you had a chance besides riding bikes?
Hey, that's a difficult one.
Yeah.
I've always been schooled in law and practiced in law. If I wasn't doing, I would have been a prosecutor.
Okay.
Initially, that's what I wanted to be.
Yeah.
For the same reason.
Not a criminal lawyer.
No. I observed that because the difficulty I had, because I had a case once where I had to defend somebody charged with rape.
Yeah.
And I discovered that he did in fact commit rape.
Oh no.
and then it's quite difficult. And sometimes
to defend.
And also to defend somebody who molested a 2-month-old baby.
Oh, no, yeah.
And
how do you
all of
do
those
that?
kind of things. So I had difficulties with that. And also not only that, the risk of sometimes the clients you represent. I've seen cases where lawyers get shot in their offices. They're shot in their parking lots because of who they represent.
Sure.
It's the risk inherent in doing that kind of practice. I'm not saying it's exclusive to that, but I've seen that. I've had people who would ask and say they want to commit money laundering using your trust account. I'll say no. Said, now this I don't like. I'm not gonna do that.
Yeah.
So I decided, you know what, I'm not gonna do that. At some point I wanted to be a lecturer.
Okay.
Not if not a lawyer, and be able to teach different things. And because I have a very special passion on teaching and education,
The role of a director, and this is my last question.
Yeah.
Is it similar to that of a CEO?
Yes, it is.
Yeah.
It's exactly that.
Do you still get involved in the cases though?
I do big cases.
Okay.
Actually, I mean, I did PIC matter. I did Sibanye strike that took 3 months. I was in the leadership while doing the whole.
While you're running the ship.
I'm reading and preparing and sitting big files. They're listening to evidence. Get calls. Please approve. I do approve. Come. You've got a board meeting. I go to a board meeting the next day.
There's a leak. There's a leak in the basement.
Yeah, and then now you still have to deal with that. In the mix of all of that. Because why I do that? First, because I love it, because it's my passion. But secondly, you must be exemplar.
That's true.
When I say draft a good award, I draft it to see what I'm talking about.
Yeah.
When I say this is how you run a conciliation, I run it best so you know how it's run. This is how you run an arbitration, I do exactly what.
Do you have the time though?
No, I don't. I make time. No, there is no time. It's quite tough. Sometimes you don't sleep, and you get really exhausted. Sometimes family suffers because there's travel involved. I mean, I go to ILO, sit there for 2 weeks, come back, I must go to Colombia, come back, you must go to New Zealand, and you do that. You must go to Parliament, you must attend board meetings, you must attend executive committee meetings, and still find time to ride a bike. And in the mix of all of that...
and be a family man.
In the mix of all of that, I must still be a student because I'm studying a doctorate.
Oh, my gosh. Yeah.
But it's my last time of studying. I'm done.
Yeah, you're brave. I've been teasing PhD for too long. Good luck.
I said, and at some point I said to myself, but why on earth did I decide to do this?
Yeah, no, you'll thank yourself.
I'll thank myself.
Yeah, the beauty of time is just it moves.
Yeah, no, it does.
Whatever happens.
Yeah, no, it
moves.
does. It does. And when it's done, you enjoy the fruits.
That's it. Yeah.
Of that. And others do more than one doctorate. I wonder what's wrong with them. I'll never do that.
Advocate Morajane Senganga, man.
Thank you so much. No, thank you very much. Man. I enjoyed this. Thank you so much.
I'm glad you enjoyed it.
Yeah, no, thank you very much.
I hope you found value in it as well.
Absolute value, because you made me revise a lot of things about what we do.
Yeah.
And some of the gaps. I always say, when you are in the union, the beauty of representing union members is that when they have problems, they don't ask you questions limited to labor.
Oh.
And they'll say they're having ninkingas. And you're waiting for issue of unfair labor practice. Bang divorce. Okay, so what must I do? Can you please advise?
Because you're a lawyer.
Because I'm a lawyer.
Yes.
Union was my best trainer.
Yeah.
Let alone these other things. But the union really, really, really trained me.
Yeah.
Because the scope was unlimited. Even if you think you're doing law only in the office, the general secretary comes and says, we're marching tomorrow. I said, oh, no, good luck. I said, no, you're joining.
I see it. Picket line.
You're in the picket line and going there because you are working for the union.
And you have to be a part of all
part of the members and marching with them in the heat and all of those things with them while they complain, you're part of that.
And you get to taste and feel
the reality. You're not sitting in the aircons with big books only.
True.
So it taught me a lot from there.
Yeah.
And I think it built me, together with practice, to be able to be the kind of director that I've been that does all of that, because I'm not in a compartment. And I know that if I lead an institution like this, if I get a call from a commissioner, I have a problem, director, what's the issue? I have this case. When I listen, I must guide.
Yes. And that means you must have the knowledge.
I must have the knowledge. Yeah. And by law, I'm a senior commissioner, let alone in reality I am. But by virtue of But I was a senior commissioner before I got appointed as a director. So I did cases. I'd appeared in different courts. I did divorce cases. I did criminal cases.
Jeez.
I did all of those kind of things. So if you take the whole package of that, it teaches one thing, that experience can't be bought.
No. You have to walk it.
Practice is the best teacher.
That's true.
That's, to me, that's the lesson that I've learned.
Here's the lesson I've learned from this conversation. That
Yes.
passion is important.
Oh,
You
it's
love
key.
it.
I love it. I love
You
it.
love it. Thank you so much. I truly
No,
appreciate
thank you very
it.
much.
Singanga blah.
King David Studio Podcast.